Hello everyone. I am introducing here a very important and much applicable presence in the present scenario of the globalization and economic conditions as well as the trade and commerce which has been developed in India as well as with the interaction of the global countries for the foreign trades. There was urgent felt of a prominent law which could be at par with the international laws. So I am talking here the Arbitration and Conciliation Act 1996. This law was felt over the 1940 Act. There was a need of introducing so many clauses and provisions to make us competent and with the coordination of international level frame of law. So the new Arbitration Act, following the pattern of UN based, has been framed, which has replaced the 1940 Arbitration Act. Now that act, the Arbitration and Conciliation 1996, was introduced in Rajya Sabha 1995 and which came into the force in 22nd August 1996. It comprises the many important aspects and it was felt for the need of that. It covers international commercial arbitration and conciliation concept. It makes the provision for an arbitral procedure which is based on the fair, efficient, capable of meeting the needs of the specific arbitration procedures. Also has further included the arbitral tribunal which has power to award over the disputes placed before them. And another aspect has been enshrined in this act, that is the arbitral tribunal within the limits of its jurisdiction. So the jurisdiction has been defined in this Arbitration Act. It has another benefit that there has no court procedures and no supervisory role of the courts over this act and the process under it. It also permits the tribunal to use the mediation, conciliation or other procedures during the arbitral proceedings to encourage settlement of the disputes between the parties. It provides every final award is to be enforced in the same manner as the decree of court. It also provides the settlement agreement which would reached by the parties as a result of conciliation proceeding. For the purpose of enforcement of the foreign awards, every arbitral award made in a country to which one of the two international conventions relating to foreign arbitral awards to which India is the party applies to it. And some features has been, salient features has been included into it, which makes it a very important and prominent act at present level. So This act is based on the model of unilateral, the conciliation rules, which aims at promoting the unification and harmonization of international trade and commerce. This act replaces 3 old statutes and introduces the conciliation. The first is Arbitration Act 1940, second Arbitration, that is Protocol and Conventions Act 1937, and third is the Foreign Award Recognition and Enforcement Act 1961. This act makes many far-reaching changes in the arbitration law, and it encourages the conciliation proceedings once it is signed and authenticated by the conciliator. Hence, here I have brought the material based on this act for you all who are aspirant for the judiciary exams as well as their course studies, and for enhancing their knowledge regarding the Arbitration and Conciliation Act 1996. I have bifurcated based on the questions and answers, which would be very much clear to you, specific answers, how it is given in the examination. So, I have taken concern the point of view of examination and have made it the questions based answer part wise, and I will be introducing relating to this act as well as so many acts in future which would also be based on the question and answer. So let us begin, and it will be my pleasure to introduce this. Thank you.